All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you for being here. We're hearing our case 1CA SA170028 versus the Steiner Oakley reporting interest. Each side will have 10 minutes to present their argument, and petitioners, you may reserve any time that you'd like for rebuttal, but you'll have to keep track of the time yourself. We have a clock on the podium to help you keep track of time. We're recording the argument, so when you come forward to argue, please identify yourself and your client so that we can keep things straight when we listen to the argument later on. We're recording this on video as well, so it will be on YouTube in a day or two. We've read the petition and the response and the reply, the amicus brief and the response. We've been thinking a lot about this case. We've conferenced it. So when you come up to argue, just launch right into your argument. Petitioner?
Good afternoon. Keith Berkshire, attorney for petitioner Heather Turner. We have a couple main premises of why we think the trial court was wrong in this case. First, we don't think that Obergefell extends exactly to the extent that the trial court and the court in McLaughlin argued. Obergefell was specifically two limited issues as far as the recognition of same-sex marriages and a mandate that the states allow same-sex marriages.
Well, but counsel, early on in the opinion, it seems to extend the right to conditions of marriage, and I would think that parental presumptions would be a condition of marriage. Is that not correct?
Well, I would disagree with that, Your Honor. While it may state if Arizona had an act, an artificial insemination statute that was gender specific, then the argument would be that it would have to apply gender neutrally. But we don't. Arizona does not have what essentially the McLaughlin court did, which was adopt the Uniform Parentage Act, which creates parentage from artificial insemination situations. We don't have that. We've specifically, in this court specifically in the Egan case, stated we don't have that. So I would agree with you if we had a Uniform Parentage Act that said the spouse of a artificially inseminated woman is or if it said the male spouse of an artificially inseminated woman is the other parent, not a presumption but a mandate like the UPA states, then I would probably agree with you that would have to be read gender neutrally. But that's not what we have here. We have a specific statute for the idea of paternity. And so while the Obergefell court does talk about about families, and Justice Kennedy goes into a lengthy argument about that, or discussion of what rights typically belonged with marriage, it doesn't by any means mandate that everything has to occur, much less it doesn't state that states have to adopt acts like the Uniform Parentage Act when they never had one in the first place. Our argument is that we don't have an artificial insemination statute for the male spouse or the female spouse. The male spouse can use 814 because it's a paternity statute, but it's still rebuttable under the same circumstances. If Lisa was a man, it would still be rebuttable, no matter what. It applies equally, and that's the purpose of Obergefell, is to apply equally. This isn't applying equally.
Counsel, another question I have is I've read in the papers that with the petition for dissolution of marriage, your client was asking for child support. support.
And, well, she did, and that was amended. The petition was amended. However, even under the McLaughlin case, they found that there's no relation between asking for child support under 25501 and the creation of parentage. So McLaughlin would actually state that you could get child support even if the other person was not found to have be a parent.
That seems inconsistent to me to, on the one hand, say that there is no parental relationship between Ms. Oakley and the child, but still ask for child support. That doesn't quite seem right to me.
Well, and we didn't get into it in this case specifically, but in the McLaughlin case, there was discussion of the fact that other states have found there's a difference between parentage and support. That the state has an interest in making sure these kids are supported, whether or not parentage is created. So,
well, and I realize this goes to a further argument than the one you're discussing right now, but does that feed into the issue of estoppel?
Well, and I guess it could. I mean, Arizona's never, besides one child support case, we've never used the idea of estoppel in any family court context. In fact, this court 2 weeks ago now, in the Bobrow case, stated that if you sign a prenup with lawyers saying that attorney's fees go to the prevailing party, that's not estoppel. So if we can't estop attorney's fees with a written contract signed when you had counsel, I have a hard time believing that you could estop something which the state considers more important as parentage. So I'm sure the court's familiar with it. I think Judge Thompson was on the panel of that. And that's a reiteration of what the Supreme Court did in Edsel, which says statutes to some extent are not waivable. And that's our argument, is that 814C is not waivable. It's an absolute. Arizona, there's no published case in Arizona that states at the time of initial divorce or an initial paternity proceeding that you cannot rebut parentage. The case out of Division 2, Hughes v. Creighton, allowed the mother to rebut the birth certificate because they stated that 814C could apply. Despite the man's name being on the birth certificate and so forth, they allowed it to apply.
Okay, so if we were able to read 1814 gender neutrally, would you necessarily object as long as we also applied C?
I think that was our argument. That was the argument to McLaughlin, frankly, that the trial court and the Court of Appeals, or the trial court, accepted that you apply 814C, it's not read gender neutrally, that in that case lesbian mothers cannot use 814C. The Court of Appeals overturned that and stated yes, they can, because otherwise that would be a violation of Obergefell. So that would be my position, Judge, that if you read it gender neutrally, which I don't think you can, because the Supreme Court in the Sheldrick case said that maternity and paternity are two specifically different things. But if you did, you'd have to read 814C, and I don't think it's waivable. If we can't waive attorney's fees, I have a hard time waiving parentage. But even if you did, even if McLaughlin is right in totality, this case is vastly different than McLaughlin. McLaughlin had a signed contract between lawyers waiving all those rights specifically. They had a parenting plan and those things. Here, they don't have any of that. The court actually found there's nothing in writing on a parenting plan. There was nothing about writing about equal parental rights. There was no written waivers of federal or constitutional rights. There's no oral or written agreements to have a child together via artificial insemination.
Well, but Ms. Oakley is listed as a parent on the birth certificate.
Correct, and that can create a presumption. But under Division 2, which recently in December held in.
Are you saying that the out of wedlock presumption in 814 applies in this?
No, I'm saying that our statute under 814 does not have a birth certificate presumption for in wedlock.
Okay.
Because that's the only birth certificate thing is for out of wedlock, which that doesn't apply. And recently, actually, Division 2 in a case called Castillo versus Lazo, which was in December, stated that a birth certificate does not meet the acknowledgement of paternity standard, which is one of the other ways that you can get in for a presumption. So Division 2 just held that those things are different. They don't have the same requirements and so forth. So it's Castillo versus Lazo, L-A-Z-O. And so it can't come up under I think it's the second prong of 814. I think it's A2, that's the acknowledgement of paternity. But even if all that applies, again, the evidence here is vastly different than what the court had in McLaughlin, which was signed, lawyer-done parenting plan, waiving rights specifically, stating that you're going to allow adoptions if it's ever legal in Arizona, waiving any equal protection claims. This came down to the court stating that they believe they intended to raise the child together. This was just dealt with very similarly in the Dottie case from this court, where it's a de facto parent argument. If you can get into intent, that is de facto parenting. If we can get around a statute and say, well, but you intended to raise the child together, you intended the person to be that. We have an intent where there's an absolute in a statute, which we think is just an end run around the Dottie case's assertion that we don't use de facto parenting in any way. One of the other things to look at in 814, why we believe it's paternity only, again, besides the Sheldrick case that says they're different and dismissed a paternity action filed by a man because they're different words under the Arizona Supreme Court decision, is it wouldn't make any sense. 814 has a presumption that 10 months after you're divorced, the man is still a presumed father. I mean, this is clearly biologically related because that's the period for having a child after conception. So one of the big things here is they're asking essentially the court to rewrite a statute to essentially make it constitutional, and we don't think that's allowed. I want to say the last 40 seconds that I have.
Counsel, we'll give you 2 minutes for rebuttal, and we'll add 2 minutes on the other side as well, please. Thank you, counsel.
I'm sorry, was there?
No.
No. And that's the argument here is that what McLaughlin did was essentially adopt the UPA. Arizona doesn't have. We're one of maybe 15 or so states that does not have an artificial insemination statute. That doesn't make it a same-sex issue. That makes it an issue that the Arizona legislature has not done an artificial insemination statute. The same exact situation for a man, it yields the exact same result, which kicks Obergefell out of this and any equal protection claims or so forth. We simply don't have it. Is that good policy? Who knows? Probably not. But that's the legislature's decision, and that's their realm versus the courts in determining whether that statute exists. I remind the court that everything beyond biology. I mean, we have older cases that talk about that adoption is the derogation of nature, and parentage rights created by adoption are legislatively only. So that's where this falls in the same idea as adoption. We're saying somebody outside of biology is a parent. That has to be a legislative decision. Non-parent rights are legislative decisions. All of this stuff falls solely in the scope of the legislature. Therefore, an artificial insemination statute has to fall within that as well, which simply we don't have.
Thank you, Counsel.
It didn't get reset, but I know you'll deal with it.
Counsel?
Good afternoon. May it please the court. Shannon Minter appearing on behalf of appellee Lisa Michelle Oakley. Your Honors, our primary argument is that Arizona law, which of course now permits same-sex couples to marry, and the Supreme Court's decision in Obergefell do require Arizona to treat all married couples equally, regardless of the gender of the spouses. And our position is that Obergefell mandates that requirement. The court did say, Judge Howes, you already noted that same-sex couples have to be permitted to marry on the same terms and conditions as opposite-sex couples. And the court talked about the constellation of marital benefits under state law, and that those must be made equally available to same-sex couples, and put a lot of stress on the importance of marriage to children and the importance of providing same-sex couples with the children of same-sex couples with those same protections.
Counsel, a concern I have with your argument is in Arizona, in ARS 25401, a legal parent is defined in terms of biology or adoption.
Yes.
If we follow your argument, which would necessarily include succeeding on the issue of estoppel, then we're first turning the presumption statutes into an irrebuttable presumption, but we're skating awfully close if we haven't already arrived at de facto parentage. And you may certainly have moral and policy arguments on your side, but I'm trying to square your argument with what we can do as a matter of law.
No, I understand. Well, with regard to the definition of legal parent, as Division 2 noted in McLaughlin, there is an additional sentence in that provision that's actually very important. It's written as a double negative, but if you jump to the affirmative notion that results from the double negative, it says that a legal parent is also a parent who is a presumed parent either under 25-812 or 25-814, so the very presumptions that are at issue in this case. I'd also just note that at the very top of that section, it says that all those definitions apply unless the context otherwise requires. So I think there's plenty of both a straightforward suggestion or assertion in that statute that the presumptions in 25-814 are also a basis for legal parentage. And I want to be very clear about one thing. We do not think that what results from our position is an irrebuttable presumption. Not at all. And one way to get at the relief that we're seeking, which is obviously for Lisa to be recognized as a legal parent, as we think a husband in her situation would be recognized and has been for years in Arizona. I mean, this has been the assumption of trial courts for decades now, that when a husband consents to have a child through artificial insemination, he's the legal father. So a ruling to the contrary would be quite destabilizing to a lot of families. But one way to get there is through equitable estoppel, as Division 2 did in McLaughlin. We think that analysis is rock solid here, and I can come back to that. But just the plain language, too, of 814C, it says that presumptions under this section shall be rebutted by clear and convincing evidence. It does not say by clear and convincing evidence that the husband is not a biological father. And as every other court...
But then what are we examining when we do that then?
Well, every other court in other states that has looked at similar provisions have concluded that it would be irrational and lead to an absurd result to permit, under the circumstances when a married couple has a child through artificial insemination, everybody knows from the outset that the husband is not the biological father, that it would be irrational and lead to an absurd result to allow the presumption to be rebutted based on an asserted lack of biology. I mean, that's the very premise of what the couple did. But it's what they have said is that what would rebut the presumption is a showing that the husband did not consent to the insemination.
But that seems to be at war with Arizona's definition of what a legal parent is biology or adoption.
Or someone who meets the presumptions under 25-814 or 25-812. That is right there in the text of 25-4014. It is the black letter law, in addition to the language at the beginning of that section that says unless the context otherwise requires. I mean, there's no question. We already know that Arizona law, I mean, there's not many cases where Arizona courts have held that a man who is not a biological father is a child's legal father. In Band versus Quigley, in Ray Marriage of Worcester, there's a whole line of cases where courts have held that somebody that we know is not the biological father, nonetheless is a legal father under Arizona law. And I think that's particularly compelling in a case where a husband and wife have made the decision to have a child through artificial insemination. There's not a single appellate decision in the entire country that has ever held that under those circumstances that husband is not a legal father. And that's based either on express statutes, which Arizona does not have, or on the marital presumption of paternity, which Arizona does have, or on estoppel principles.
And the way you read 814 allows for a situation where the presumption can attach to a non-biologic parent.
That it can attach?
Yes.
Yes, sir, absolutely. There's nothing in the text of that statute that would preclude that attachment, and it happens. I mean, I want to be clear. Biology is important. I think probably in most cases the husband is the biological father, but there are certainly circumstances where he knows, the wife knows, others may or not know that he is not actually the biological father. That presumption absolutely attaches. That is an unqualified, that language in that provision is unqualified.
And then the way you read 401, the definition of legal parent, particularly that last sentence, it expands the definition of legal parent in your mind beyond a biologic or adoptive parent.
I think that sentence is there for an important reason, and if it was literally true that the only way to be a parent under Arizona law was through biology or adoption, there would be no point to that sentence. But I think it's there to indicate that there are going to be circumstances where someone is a presumed parent, either under the voluntary acknowledgement of paternity provisions for unmarried fathers, or under 814 for married fathers, where somebody can be a presumed legal parent without having a biological relationship to the child.
Well, I apologize. Can you point out that language to me again? I got the statutes here.
Yes, it's written in a rather awkward way. It's a double negative, but it says legal parent does not.
Yeah, no, but where is it though?
Oh, it's just right. It's right in the text of 25-401, subsection 4.
Okay, thank you.
And this does go back, I think, to what are the purpose of the paternity presumptions. And we do think that the court in McLaughlin got that correct, that the paternity presumptions are not driven by intent to identify the biological father no matter what, but that it's really driven by the state's interest in the welfare of children and the integrity of families. And we do have the Hunt decision from the Arizona Supreme Court from several decades ago emphasizing that really from the state's point of view, the primary purpose of these provisions is to make sure that there's two parents who are identified as being legally responsible for the child's support. And of course, if on Heather's view of all of this child would end up with one legal parent. I will say also that in addition to there being no appellate authority for when a husband and wife have a child through artificial insemination, not recognizing that they're both legal parents, I'm not aware of a single appellate decision anywhere in the country that has permitted a wife to disestablish her husband's paternity when there is no other candidate, there is no alleged genetic father, and thereby leaving the child with only one legal parent. And I think it's significant that in 807C, 25807C, which sets out the circumstances under which the court can order genetic testing, it says it can order testing of the mother, the child, and alleged father. I do not believe there's any basis in the Arizona law for ordering genetic testing of a husband who is a presumed father at all. Like the mother can point to another alleged father, an alleged father can come forward, the court can order the child's mother, the alleged father to be tested. But if you have a husband who is a presumed father, wants to continue to parent the child, and there is no other candidate to be that child's father on the horizon, I don't think the statutory scheme provides any way to compel him to undergo genetic testing and leave the child potentially with only one legal parent. And I don't think there's any case law in the country that has permitted that either.
Mr. Berkshire argued that the McLaughlin case, in that case, the court sort of exceeded its authority or intruded into the legislative arena by essentially adopting the UPA. What's your take on that?
No, I mean, it's not adopting the UPA at all, and there's a number of states that don't have the UPA and don't have any statute addressing artificial insemination that simply rely on the marital presumption, which is what would apply here in Arizona, and apply a similar kind of estoppel type analysis, or the other analysis that I suggested to the court, that it would just be irrational and lead to an absurd result to interpret 814C to be rebutted by a lack of biological evidence, as opposed to you could rebut it by showing that the husband wasn't aware of the insemination.
Counsel, your time's up. I have one other question. I wasn't sure from the papers, is your estoppel argument tied to the presumption statute 814B and C, or is your estoppel argument broader that because of the positions that Ms. Turner has taken, she can't dispute Ms. Oakley's parentage regardless of the presumptions?
No, it's certainly tied to the presumption in 814A1. That presumption is a critical piece here, and then the trial court, was very careful and held. The trial court recognized the facts here are different than in McLaughlin to some extent, and that's why she held this whole evidentiary hearing to make sure or to determine whether there were facts in this case to support an estoppel argument. She made that point very clearly on page 47 of the appendix, and then if you look at pages 126 to 130, it's a very detailed analysis of the facts that would support estoppel in this case. But yeah, it is tied to the presumptions.
Okay.
Yes. Absolutely, yes.
Thank you, counsel.
Thanks so much.
You've got 2 minutes there.
Again, Keith Berkshire for petitioner. One of the things that counsel pointed out was they said this wasn't irrebuttable, and specifically he stated that it was you could rebut it with no consent, and that doesn't actually. If that's the standard, then they lose, because specifically what the judge found, it was obvious and very clear there were no written or oral agreements to have a child together via IVF. That was the judge's finding. Then it goes into this idea but they did decide to raise a child together and be parents together. If there was no consent to the IVF under what he specifically stated, then the judge's findings find that there was no estoppel. They point out the Bond case and the Worcester case. Worcester was a Rule 60C case, that there was already a trial finding, and they said you couldn't go back under Rule 60C. Vastly different standard than just a estoppel standard. Bond was whether the court would do an analysis first before it would let
And Worcester also has it's close to equitable estoppel, the old kind we know about where a party takes a position in court and then tries to take an opposite position later, because the Rule 60C
and it was specifically
problem was that the woman had testified that the guy was the father.
And in court, and a judicial finding, and then a motion to set aside under 60C, which again is a vastly different standard. And again, Bond was somebody trying to come into a marriage where the court said, before we even allow it, we're going to ask and whether that this could be in the best interest. 2 different standards. We don't have any cases that say you can't, during an initial case, dispute parentage. And that's what this is during an initial divorce. I mean, you're going to go through every case. No one would ever be able to dispute parentage if you say you act as a parent, they were on the birth certificate, all these types of things. No one would ever be able to dispute parentage in a marriage. It would make C meaningless, because any situation, somebody's going to go to soccer practice and say, I'm dad, or whatever, and then years later, any situation, C would be irrebuttable. Not a rebuttable presumption, it would make it irrebuttable in all cases.
Can you briefly address the argument that there are three ways to prove legal parent in Arizona.
Under 401? Yeah, and I would agree that that sentence is there for a purpose. There are people that have, that situation comes up all the time in our world of, one of the kids might have been born out of wedlock and they had two during it. So the one kid, and they're only on the birth certificate, they would have to prove it. It just means that there hasn't been a court order yet. So any case where they just sign the birth certificate, an out of wedlock case, they've signed the birth certificate, not an acknowledgement of paternity, that case would apply. So it's a really common thing. That's how you get into court. You say I'm a legal parent, then the court orders the DNA test. But it doesn't say that you just have this irrebuttable presumption if you're alleged to be the father. It's got to be rebuttable. Otherwise, C has no meaning. If you can't rebut it and you're stopped, every case should be stopped.
Thank you, counsel. We appreciate your arguments today. They've been very helpful. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.